Hi, and welcome to our continuing education with New Century Planning Associates. Bob, we've got a great topic today. In fact, we have a really wonderful special guest with us. But we're talking about divorce, and this is a tough issue for a lot of folks to tackle. But it is an important part of the equation. If that, in fact, is the reality or going to be the reality with a couple, we want to make sure at New Century that we're taking care of all facets of retirement. So if you would be so kind as to introduce our wonderful guest today.
Yes, we are thrilled to have Michele Crupi with us. She's a family law attorney for 25 years, and she's with a partner with the prestigious law firm of LaRocca, Hornick, Rosen, Greenberg, and Crupi in Freehold, New Jersey. And Michele, thank you for coming here today and helping us on this tough subject.
You're welcome. Thank you for having me.
Yeah, and Michele, I'll kick it out right now, and I'll start kind of simple here, but is it a true statement that a divorce could take a year or 2 years or longer?
Absolutely, especially now, post-pandemic, with the courts being so backlogged. Traditionally, the courts would usually try to get your case processed within a year's time. And the time, I usually tell my clients, depends upon how fast you can come to an agreement, a mutual agreement. If you can't agree, the court is going to decide your case and put you on the court calendar and on their discovery tracks and their timeline. And usually the court can take up to a year and now even more. And that could be really emotionally painful for people going through the process because they need closure, they need answers. We recommend mediation that can shortcut and expedite the process, and it could be a lot friendlier. But generally speaking, it can take up to a year or even longer.
Wow. Michele, you're a certified family mediator. Can you tell us what mediation is?
Sure. Mediation is alternate dispute resolution. It's a method of resolving your case without the necessity of any court intervention, or a court or a judge telling you what you're going to do and how you're going to do it, and the decisions, major decisions in your life concerning your finances and your children, can all be fleshed out before a neutral person that you would hire who would help you come to a resolution. Some people decide to do that with their attorneys present, though they're not advocating for you, they're there to advise you. And some people choose to just go straight to mediation without representation. And the thing to know about that is the mediator is not going to give you legal advice, but try to bring you together so that you can come to a resolution on your own, and make certain concessions that you choose instead of a judge.
Wonderful. And Michele, for the sake of retirement planning, there's one big piece we want to talk about today, and that's, of course, property settlement, right? And there is a financial tool out there, a Quadro, and if you wouldn't mind taking a moment and explaining what that is.
All right. Quadro is the most, it's probably the most difficult thing that an attorney and a client have to navigate together. It's a qualified domestic relations order. This is it's a court order that enables the court to allocate the participating spouse, that's the person who's enrolled in the plan, retirement assets. This Quadro, they apply to ERISA plans. Those are plans governed by the federal government. And that is the only way to divide a plan that's qualified like that. If you don't have a qualified domestic relations order, you can't receive the funds from the administrator, from the participating spouse's plan. If I make that clear enough, basically things that are exempt from that are most IRAs, but most union plans and other qualified plans, in order to distribute the marital portion, require the hiring of an actuary to get the plan documents and work with the administrator of the plan to distribute those assets to you.
And let me do a little follow-up there. Is there an expectation of penalty for early withdrawal, or does the Quadro kind of put a limit on a penalty, or maybe remove a penalty altogether?
So you could do things with a Quadro that are within the plan limitations. You can't really go outside of what the plan allows you to do. But the things that to keep in mind in getting a Quadro facilitated is it allows for a tax-free transfer of retirement assets to the spouse.
Okay.
And Michele, this can be a 401k, a pension, a 403b, a union plan?
That is exactly what it applies to.
So it may take some time, but it sounds like it's worth it because you're talking about the tax-free transfer or rollover of what could be significant money.
it's essential. You can't, I mean, that's probably one of the first things you need to look at when you're settling a case, is getting those plan documents. They could be very, very thorny. There are certain limitations, certain things you can't do and you can do. There are things that happen if you don't have the correct language written out, especially in your agreement. So it's really important from the get-go to understand the plan documents and to work with an actuary or somebody who's familiar with the plans to draft that order. If it's not written properly, you will not receive your asset. And that could be disastrous, especially in the event of the death of the participating spouse. There are some plans that, unless you have particular language written into the order, they will die with the participant.
So 2 little quick follow-ups from there. How long does it usually take from the time that you initialize the quadro to the time that it's fully executed and dollars are available? And then what is the rough price range for that? I know it's going to vary from actuary to actuary who's going to prep it, and usually a financial planner can get involved in that if I'm not mistaken. But if you could answer those 2 questions, please.
I mean, the cost varies depending on the complexity of the plan. Usually it's about $500 per quadro. They do take several months because you have to communicate with the plans first, try to get the plan booklets, all of the statements so that you can examine the withdrawals and the deposits into the account, try to ascertain what's marital, what might be premarital, and what might be post-complaint contributions that may be exempt from distribution depending upon the agreement you reach. So all those things have to be negotiated before you actually enter into the agreement that actually ends up in the form of an order. But once that order is entered, then it has to be reviewed by the plan. They have to accept it, send it back to you, to the attorney. The attorney then has to review it, and then the parties have to execute it. Once it's fully executed, it then goes to the court for approval. The court will sign off on it, comes back to the attorney or the litigants if they're not represented. And then it has to be filed with the court. Once you get that filed copy back from the court, it has to be served on the plan. So these are all critical steps. And it's very important that they're followed and that the procedures are followed correctly.
Right.
Michele, that is quite a process there. Hey, I'm glad that we got this financial term put together. It's a big part of it. That transfer of assets is such a major part of the divorce. Hey, let's move on now, Bob, to those top 10, if you will, my friend.
Okay, so Michele, in no particular order, we know that there's a lot of things, and you said, maybe early on in the process, you try to have people start thinking about these things. So some of them may seem obvious, but if you could explain and comment on these as we go along, because, if somebody accidentally forgets 1 or 2 of these things, I think there may be implications. Obviously, the quadro with the actuary and the court and all that stuff, that's going to be a monitored process, right? So that's a little safer. But for example, is one of the first thing they should do cancel joint accounts, establish their individual accounts at a bank, at a brokerage, automobile loans, mortgages, that type of thing? That can be a lot of work too, right?
Sure can. Any titled asset, that means something that's owned like jointly or individually by title, should be dispersed accordingly. So if it's going to be your sole asset, make sure you go to the bank, make sure your spouse goes to the bank with you, signs off on the asset. Same thing with something that's held at a brokerage firm. The broker would help you navigate through that, look at the agreement, see whose names have to be removed, what has to be transferred. If it's not done appropriately, it's open. It remains open to attack by something that could be not a very pleasant outcome. For instance, you leave your spouse's name on a joint account that you're supposed to receive in a divorce. The party who's not supposed to share in that asset then gets into an accident or owes money to somebody, and there's a lien imposed against them. What ends up happening is, if there's a judgment or a lien, and it's enforced, they could attack your asset. Now, that's one of their assets because it's still in their joint name. There goes your asset. And the only way to try to recoup that or get that back would be to go to court on an enforcement motion. That takes time. And by the time that happens, sometimes, it's money. And if the other party can't get it back to you in a lump sum, you're going to wait for your asset.
Okay, so that's serious. I didn't think of that. But let me ask you this: if you forget to take the X off a joint account, can he or she, because they're still on it, can they invade that principal? Or the bank? Is there some protection on a joint account, or can you lose money that way too because you didn't get around to it?
I know exactly what you mean. If there's not a freeze on the account from the beginning of the case, and sometimes we do that in special circumstances, but generally not, because it's usually a working account that parties are paying bills out of, or it's a savings account and they just don't freeze the account. If the other party's name remains on that account, and it's never taken off, they're free to go to the bank and take all the money out.
So you must have a horror story or show. You must have run into this a couple times at least, right? Where that happens.
Definitely, especially when it comes to the lien imposed. But we make sure that we tell our clients, run to the bank, take your name off, make sure that your spouse cooperates. We get the people that don't cooperate or forget. But sure, that happens.
Real quick, if they don't cooperate, they have to be compelled by a court order, I guess.
Yes, you have
And the
to
whole thing
file
is
a
just
motion with the court.
slow
It's
and
not-
expensive, and that whole process, because I know I've run into it with divorced clients. The ex is not playing, and they've got to compel by court, and it's slow and it's expensive, right?
Absolutely. It's a motion. You can't just walk in the door and say, hey, judge, he took my money. And you also can't file, in most instances, an emergency application because it has to do with money. And they don't believe that that qualifies under the order to show cause as something with irreparable harm because it's money. So you have to wait your turn. You have to file the motion. That takes time to draft. You have to get your day in court. Then you have to abide by the court's calendar as to when they're going to hear you. Then you get your order. Sometimes it's not right away. Sometimes it's not simultaneous with the date of the court date. Then you get your order. Now you have an order that says he has to give them, or he or she has to return the funds. What happens next? What if they don't? They're not self-executing. Then you have an order that, and most of the time you have to go back to court. Hey, judge, your honor, they didn't comply with this order. Now I want sanctions. I want, a stiffer penalty if there's no compliance. So it is quite a process. And unfortunately, you have to pay because you're paying for your attorney's time to draft all these documents to go into court. So it's costing you a lot of money, a lot of time. So doing it correctly from the get-go is advisable.
I think we should stop talking about this subject right now.
Yeah, well,
I don't think we should give anybody any more ideas.
Yeah, so
let's
just
go on to number 2.
Yeah, one quick follow-up to all of the financial accounts, whether it's IRAs, 401ks, is really getting that beneficiary changed, right, Michele?
Absolutely. Always follow up with the, whether or not it's life insurance and you're supposed to change a beneficiary or update certain things. There's cases where, even though the agreement says that the life insurance beneficiary to be changed, there are instances where you don't actually physically make that change, and there's case law on that. There have been issues with the insurance company releasing the assets to the person who was named in the first instance as a beneficiary on the policy. So it's really important to go through your financial documents with your advisor, make sure that anything that can be changed and should be changed is changed.
So are you saying there's cases with retirement accounts or insurance, things that skip probate and go directly to the beneficiary, that sometimes it ends up, unintentionally, the person dies and the money goes to the ex? That can happen.
Absolutely. Titled assets like that all the time.
So it's not only change accounts while you're living, but make sure Betty's beneficiary too.
Right. If it's not by operation of law, like sometimes the house will by operation of law change title, but most of the bank accounts, the life insurance and retirement accounts, beneficiaries should be changed and updated.
Okay, great. Third one, kind of obvious. Build an emergency fund of a few months at least and create a new realistic budget. You're on your own now. Time to do a new budget, right? And try to be realistic about it.
Absolutely. The theory is that if you're receiving support or paying support, you're supposed to be able to maintain a lifestyle similar somewhat to what you enjoy during the marriage. But as we know, supporting one household is a lot easier than supporting two. So that's when I really advise my clients to sit down with somebody, go through their budget, look at what they're going to receive in assets, look at what they're going to receive in support, child support, see what they need to live, see how they could spend their money, see how their investments will help them, what they can take out of their investments, what their budget should be. There are some people that have absolutely no idea how to manage their budget, never did it before, and it's essential.
You mentioned child support. Is child support a lot more common than alimony these days, or are they equal?
Well, any case with a child, when there's a child involved, there would be a requirement to pay support. I mean, that goes without saying. Alimony is not always a given. Alimony is statutory, depending upon certain factors. There are different types of alimony. There's limited duration. There's open durational, rehabilitative, reimbursement, depending on statutory factors and the factors of your case, whether or not you're entitled to any of that. And the factors, they go from, the duration of the marriage, the ages of the parties, the needs of the person, the ability of the parties to pay. So that's an analysis on a case-by-case basis. In a case where you have children, it's a given there's going to be a child support obligation. Very rarely there wouldn't be.
My next one that I have on here is update adjust personal insurance coverage. Auto, home, life, health, disability, long-term care. That's important, right, Michele?
Definitely. Most of the time you're getting divorced, you need to update, you need to get a life insurance policy to secure your obligations, to secure your new obligations. You need health insurance. You need to either follow through with the COBRA benefits or go out into the marketplace, find your own health insurance. There are other issues, disability. Now, that's a policy that you might not have had before, but you might think about a little bit more now that you're on your own. Definitely have to sever the insurance policies. You're no longer living with your spouse. It's no longer legal to keep the insurance at the same place as it was before if you moved out. You might need different levels of liability. You need different coverages. The home, you want to change the people who are insured. If the house was being transferred to one of the parties, you want to update that. You might need some supplemental insurance. So yes, there are many, many insurance issues that should be reviewed with a professional.
Seems like a lot of work. This one's worse. And you mentioned that people are unaware. A lot of people getting divorced are unaware how to even generate income. So step number 5, build secure future income streams that will last as long as you do. And these, we ideally want to layer these on top of any Social Security that you're going to get, maybe a pension. But that's something I think a lot of people are going to need some help with. Now they have some assets. Maybe they were not the ones familiar with it or managing it or know how to turn it into income at some point.
That's a definite. When you're receiving these assets, I mean, I've had clients that say, I don't know what to do with them. He's transferring or she's transferring an IRA to me or an annuity or an account or an investment account. I don't know how to invest it. I don't know where to invest it. I don't know how much of the principal I could use. What are my dividends going to be? Absolutely an opportune time to sit down with somebody, have them look at your assets, have them look at your income stream, your potential, your future income. And again, what I said before is I have them sit with a financial advisor once their assets are divided. And there's some pretty cool programs, I think, that can generate spreadsheets and different scenarios with different investment opportunities and a great deal of help out there that even go beyond the kind of advice that an attorney would give.
All right, I know that we've got about 3 or 4 minutes left here. I love these very robust answers from you, Michele, but we're going to go with some shorter answers if you don't mind to get through the rest of these. Check your credit profile and scores, all 3. I mean, that's kind of a given, right? You really need to be aware of your credit.
I absolutely advise my client to run a credit report. There's a free creditreport.com at the outset. Make sure there's nothing out there that you don't know about.
Also, kind of makes sense, you now need to build or update your own estate plan. Certainly power of attorney documents and a will. If you're by yourself and something happens, POAs are going to be really important. So that's something that should be done pretty quickly, right?
Absolutely. We have language that we put in the agreement regarding assets that are not going to be going to your spouse any longer, but sometimes there's a will that's outdated. You want to get that updated. You want to get any new assets covered under the will. You absolutely should seek the advice of someone who can help you with some estate planning.
Yeah, and this is another one here. Run new tax projections, right? You're now two separate households. You're going to be filing income tax. You're going to be penalized for being single rather than married. So clearly you need to get that piece worked out, right?
We absolutely do consult with tax advisors, sometimes absolutely during the process when we're dividing assets, because different assets have different tax consequences. You also, have a different standing after the divorce. So you want to get that kind of advice as to, your filing status and how the assets are going to have, what tax consequences you're going to suffer from certain assets and selling certain assets and keeping certain assets.
And here's the ninth one related to what we talked about before, and I've seen some bad results here. They want to review the assets as they currently stand. They may be too risky for their preference. They may be not risky enough. There may be bad allocations that have to be reviewed. There could be a market crash in the middle of the divorce process. So freezing or locking in values and having the asset allocation mix comport more to the divorced person's risk tolerance is really important, I think, because a lot of times it's at askew.
Sure, what might have been appropriate during the divorce, during the marriage, when you were even maybe younger, there were different strategies from different age groups and from different risk tolerance. So that's, yes, absolutely another issue that needs to be addressed.
Last question. So kind of small, but buy a shredder, buy a safe, maybe a personal locator beacon, get POAs done. Start thinking these are things that as a single person, maybe you're not single forever, but these are really important. Would you advise that the single person give passwords and digital access to at least one loved one? I'm thinking if the newly single person is incapacitated either temporarily or permanently, and nobody knows how to get into anything, it's a nightmare. Should they not share that information carefully with at least one trusted loved one?
It's a trusted person, even if not a loved one.
True. Okay.
One person that has that information, they be kept in a very confidential, secure environment.
Good.
Michele, thanks so much. Invaluable information. We really appreciate your time. And hey, can we have you back sometime?
Thank you. Absolutely.
Thank you, Michele. Great information. Appreciate it.
And if you want more information about what we spoke about here today, hey, give us a call in the office. We'd love to start a conversation with you. The great folks at New Century Planning Associates, we're here to help you retire well.